Hey, please do not.
Yes.
Item number 20 maybe come up after a week.
কলম সলম দিব লাগে ইয়াত একদম নিদি পেনে কলম পেন্সিল না এটা নমনা করতে বাবা হয়ে যাবে আপনারা yes
Item number 20 maybe come up after a week.
after a week
Right.
20
Who is it?
year for whom
Petitioner.
yes for the government
Wait.
Mr. Who is there? Madam, you are there for the government. On the prayer made on behalf of the petitioner, list after a week.
Right.
Is there any interim order?
No, man. May I please, your lordship?
Yes.
Lordship, I beg to mention item number 8, your lordship.
8, yes.
8. Item number 8, your lordship. So in this case, your lordship, the legal heirs to the petitioner has informed that petitioner already expired, your lordship. That I may be allowed to file substitute application.
19 matter.
Lordship.
When was the expiry?
Lordship, just they have informed me, lordship.
19 matter, we are not going to adjourn like this. Sorry. Let it reach.
Please, it is
Please switch on the microphone or speak loudly. Yes.
item number 27.
Yes.
I'm on behalf of the petitioner.
Yes.
It is required to file the reply today, but the petitioner is out of the. So
Have you informed the other side? Have you informed the other side? You have to inform, then make a mention. Don't make a mention like this. Inform will adjourn the prayer. Grant the prayer. Inform first, not now. Item 2.
Wait, here, the one of the court mallet had reacted the petitioner mallet to have the resolution mallet. Can you see the water dated 2/8/2022 mallet?
2/8/22.
2020. Yes, mallet.
Yes.
Mallet, the I just
Just a
thought
minute.
the one of court has
Consistent reason.
the petitioner mallet
Was there
have
a
it
taking
petition mallet before the responsible authority mallet, particularly the inspector of school as well as the principal mallet. Accordingly, the petitioner as
Yes, what has happened thereafter?
nothing mallet. Still mallet, things pending mallet, waiting
Yes, it's for the secondary education department. We are having bench tree, isn't it? Why is education department council is not there? Should this go before the particular bench?
No,
This is go before bench 2, isn't it?
yes, we see up to there. It is
Hmm?
yes to matter.
No, we are having bench 3.
COVID, no, mallet. Actually, mallet, it was earlier mallet. COVID, it is not done by one of Mr. Ikin, not by him.
There will be 2 bench 2, I think. Bench 2 এখনই আছে নেই।
That is why mallet it is
Bench 2 এখনই আছে নেই। 13. Good. Put it, two and zero, button two and three. Let it go before the appropriate bench. There's another court taking up bench two matters. Otherwise, we'll have a difficulty. The council will not be here. We are having bench three. Place before the appropriate bench. Within bracket, civil bench two.
Item three.
In our case also similar issue is there, but tense two matter, my lord. Whether you have to take it up. We'll take up the matter.
What is the subject matter?
I will about, my lord, before starting, my lord, my senior is coming on the way, my lord. Therefore,
What is the subject matter?
As well as-
We are not hearing the matter. What is the subject matter?
My lord, regularization of subject teacher, my lord, of
Mr. Hawk, let it go before the appropriate bench. Place before the appropriate bench, civil bench two.
Four. Item four.
record.
To take the lot on the last document. Our court is requested to give a comparative statement of the petitioner and the private respondent
Regarding,
regarding their
Promotion.
promotion lordship. As both of them are grade 4 employees lordship, their recommendation and other documents, comparative statement is
soundটো অলপ কম হৈ আছে নেকি? অকমান বঢ়াই দিব পাৰিম। Soundটো অকমান কম হৈ আছে নেকি? অকমান। অলপ বঢ়াই দিব। What is your name, Mr.?
I am petitioner.
No, no, your name?
Arun Chandra Chaudhary.
Arun Chaudhary. And respond, private respond.
Private respondent for naming.
login under the
You are for the private respondent.
Both are having same qualification.
You have filed affidavit in this matter.
lordship, yes, earlier affidavit is filed in this matter.
Yes, you have filed. We can hear this matter?
Yes.
Yes, please proceed.
No, in this case, petitioner service was regularized. The common order, Annexa 4, page, Annexa 4, page 27.
Services,
And Master Walker, he was a grade 4 post. Government of India, Government of Assam has engaged prior to continue working without break. Regularized the service of the petitioner.
when
Is-
20,
Regularized the service of the
page
petitioner.
27.
27. He is working since 1/10/1986.
1/10, 1980.
6 Nalbari, ceiling plant attendant. Serial number 146.
Where is, which page?
Page 27,
Yes,
6 Nalbari, and ceiling plant attendant 146. Om Chandra Chaudhary.
yes.
Date of his engagement is 1/10/1986
Hmm.
and date of retirement actually, my lord, engagement, Master Walker was 11086.
Yes.
And other is Nogin Chandra Tala, page 28.
27, serial number 6,
His engagement was later on after
26.
after 6 years. That is 162, serial number 28. Oh, no, sorry, my lord, page number 28, serial number 162. His date of engagement is 1/10/1992.
28.
28. My lord, page number 28, serial number 162. Next page.
162.
Nogin Chandra Tala,
Same Nalbari.
Nalwar, yes, man.
Response number 5.
1/10/1990. He is 1/10/1986. 6 years later, he was engaged as master of law.
1/10/1992.
Criteria for promotion from the post of criteria. Minimum qualification is graduate. Lordship kindly see page 62.
62.
62. It was amended in except for conferred on provision of Article 309 of Constitution of the Governor of Assam, here pleased to make following rules further to amend the Assam Director Establishment Ministerial Established Rule 1973. It is amendment of Rule 10(2). In the principal rule in Rule 10, for the existing sub-rule 3 following shall be substituted, namely by selection on the basis of suitability from amongst the grade 4 staff officer who possess the bachelor degree from a university recognized by the government and also pass such other qualifications as laid down in sub-rule 3, Roman 3 of the Rule 12 and has rendered not less than 7 years of continuous service in the office of the first day of the year on which the selection made.
Suitability is the ground.
Yes, my lord. Provided that vacant number vacant to be filled up by 10% vacancy. Education qualification is page 64.
What are the essential criteria? Eligibility criteria rather?
The generation and
Number 1 is suitability.
suitability.
These rules for
And seniority is also counted. Is for the post of junior assistant.
just a minute. Service লোক এখন থেকে কিতাব আছে।
It has been-
Thank you.
it has been-
For
on-
Okay,
In the-
after
In the graduation list, Lord, can you see page 71?
7-1. Yes.
petitioner name is at 37, serial number 37. Type copy is there,
Yes.
37, and private respondent name is serial number 128. As per graduation list, 13/11/2017. Provisional graduation list, employee under subordinate establishment regular, MR worker, master worker.
Additional, 47. And Nagan Chandra is at 128.
Yes.
128, R5, okay.
And he has passed the certificate course of Institute of Cooperative Management, Guwahati. Maybe it's done. Page 70,
70, yes.
70.
Who has passed?
My petitioner. Right. The diary development, actually, office is diary development. The government of Assam. He has passed the Institute of Cooperative. Cooperative is also very much necessary. Management of Guwahati training. This is certified training program of cooperative management of DCS 9/1/2017 to 13/10. And also,
No, you have participated in a program of 3 days.
yes, my lord, 3 days. 3 days. It's a training program, my lord.
Oh,
And also having the same qualification with the private respondent. And he was interested to do some work of grade 3 stuff. Though he is a grade 4 stuff, my lord,
yeah, the petitioner.
petitioner.
Where is that?
Lord, can you see page 79? Serial number 7, owns under type DCS and stand. The smooth proper functioning of today the superintendent town milk supply of the following arrangement is hereby made temporary with basis of immunity.
What is the date of this order?
Date of order is 30/12/2017. Annexure 13.
Okay.
Annexure 14 also.
Where are you here? Which serial number?
Serial number 7. Actually, he's ceiling plant assistant, ceiling plant attendant, group 4 post. And thereafter, can you see page page 81, annexure 14.
81.
81. Serial number 3, Arun Sodhi, status report of Nandini Mohila, DSI Dekhal, as Director, Deputy Commissioner, Kamar, provide memo number 7. We are requested to submit status report of Nandini Mohila, Duddha Utpadak, Samobai Samiti, Ghanasiam Basti, Jurabad, and Deupal Kalpataru Durga Utpadak, Samobai Samiti, Hora, immediately onward transmission to Deputy Commissioner Kamrup for next action. Thereafter,
Yeah, how is this relevant?
actually diary development is given some extra responsibility to this. Though he is a sitting plan attendant, these are works are entrusted to group 3 stuff, madam, group 3.
Okay, then
And Lordship, after that, he was selected he was interested to very much various job, which is not related to his work, but group 3 post. And also, minute the meeting of selection committee held at 16/2/2018, page 82.
yes.
Here, interestingly, all the candidates, Lordship candidacy, I want to apprise the Lordship. Page 83, 1C Robin Das. Remark was given since other candidate under the job does not fulfill relevant criteria, loan candidate is recommended. And other also, junior assistant, she began not the Amandan Thomas, since the post is direct to a national 10 vacant is considered. And remark has all senior assistant, junior assistant. Here, Lordship kindly see page 84.
Hmm.
Seal number 2, Nogenta. Since the post of direct recruitment necessary on necessary, only 10% vacancy is considered.
Hmm.
On what basis he is considered, whether he is ACR or any other, that record was called for, my lord. There was no remark that he is more suitable than the petitioner. My lord, and if there is any adverse remark in ACRT, that has not been communicated to him. Any adverse remark or any stigma in his service that never has been communicated. Lordship, based was well known to the Devdatta case, my lordship. How the private respondent board was selected, that has to look at very comparative statement, ACR and his performance, all other things. Whether that has been considered by the DPC or not, Department of Promotion Committee, and selected him.
Okay. This is your case.
Yes.
So if we reframe your contentions, you were first senior to him
Yes, ma'am.
in the initial engagement,
Initial
from the date of the
engagement.
initial engagement.
Engagement. ma'am.
And the date of regularization also states that you are senior to
Yes,
him,
ma'am.
number one.
Yes.
Number two, in your, after your regularization, you have been engaged in many other activities which pertains to grade 3.
Yes.
Your services have been utilized. There are documents.
Yes, madam. And
Number third, you meet all the requirement under the amendment rules. You
Fulfill
are
the
a
already
you are a
eligibility criteria.
graduate. You have done 7 years of service.
yes, ma'am.
So you are on the zone of
And
consideration.
also I am a bachelor degree.
Yes, that you're a graduate, we have seen. You have done some additional program also. You
Yes,
have,
yes.
and lastly, you have stated that in the minutes of meeting where the private
There is no,
respondent,
no remark.
no details have been given how he is preferred over you.
Yes.
That is your case.
Yes, ma'am.
Okay. Madam,
I'm relying on our affidavit noted. As both the petitioner and the private respondents are were
you have filed
appointed
affidavit.
as lordship,
You have filed affidavit.
we have filed affidavit lordship.
Is it by Horen Buragohai?
Or in Burago.
4th December.
Yes, sir. Title, Paragraph 6 lord
Para 6.
of our affidavit.
Yes, please.
Where it
Yes.
that the petitioner is regularized against supernumerary post and is not governed by the district establishment mineral service rules 1973 or the directorate establishment mineral service rules 1973. However, they are promoted by considering their continuous service, special report and recommendation from the controlling officer. Okay. So, and the comparative statement I have submitted, there are one recommendation and one special report is there, which is the private respondent's report is better than the petitioner lord.
This you have just handed over.
Handed
Okay.
In
You said that 73 rules are not applicable.
further lordship, the date of regularization of service is same for both the petitioner and the private respondent. And the gradation is the date.
What are special reports?
Special reports are lordship. one report, the special report is given by the Deputy Director, Dairy Development Department, Lordship.
Where do you have?
I've already submitted that, in that report.
You have handed over today.
Yes, Lordship.
Yes.
One recommendation letter and one special report where the integrity of the officer or employee is very good in case of the private respondent.
Just a minute. Organ Talunda. Otherwise, he meets the eligibility criteria under the rules. Though the rules you say are not per se applicable because these are supernumerary posts, supernumerary vacancies.
Now 6.5 years has already completed these in this grade 3 post that contacted this earlier post was the supernumerary.
So,
post.
Amit, they have given a competitive statement whereby the internal reports are there. Your client has been termed as very good.
Mm.
And whereas respondent number 5 has been termed as excellent, outstanding.
ACR, they the lot to kindly see their affidavit in opposition.
Of
Page, government, page 3,
page 3.
page 3,
Yes.
TL number 12. That
Madam, anything else before we go to Mr. Ahmed? Anything else?
We have another criteria. Gradation list is only for the purpose of retirement. The data section there is for grade 4 post, there is already. That's such.
para 12. Here
Just,
is
just a minute, we'll come to you. Let us hear the learned counsel
Yes.
for the respondent first,
Yes.
then we'll come back to you. Yes. What is your name?
Empat.
Empato.
I think. When
Here for R5.
Content number 5, complete with 5.
Okay.
My case,
You have filed affidavit.
yes, but I have,
When did you file?
I have. 14 November.
14 November, correct.
Yes,
14/11/2023.
20.
Yeah, okay. Yes.
But now my case is where the promotion,
Come to this side. Use the microphone.
when the promotion is given following the relevant rules in letter and spirit, then the interference of this honorable court is not called for. This is my primary submission. Now, Lordship, the basic qualifications of the petitioner and the private respondents are the same. Similar to the petitioner, the private respondent also time to time entrusted with some other work in the department, and he successfully completed his entrusted work. Now the point on seniority. Lordship, they are regularized on supernumerary post, and it is optional to them. As soon as the incumbent relinquishes that particular post in any manner, the post is abolished. Now, in this case, Lordship, seniority is not counted for any purpose, because
in apex code also said the tenure of service during ad hoc or any master role or temporary period cannot be counted for seniority. And rule also says
Oh,
that
yes, yes, which,
yes, Lordship, it is in Ashok Gulati, 1986 supplementary SCC. I have also stated in my
1986,
supplementary SCC, page 424. I just want to read Lordship small paras of that particular judgment. 1 and 22 of that particular judgment. May I read, Lordship? 1986 SCC,
supply SCC.
supply SCC, Lordship, 597 page. The first paragraph of that particular judgment contains about the factual aspect of that case and the issue. May I read, Lordship?
You read the ratio, read the ratio.
In this appeal by special leave, the third question involved is whether respondents 1 and 2 were entitled to the benefit of the period of service rendered by them as temporary engineers on an ad hoc basis in the irrigation department of the Public Works Department, State of Haryana. That is prior to their appointment as assistant teachers on regular basis on April 21, 1975. This is their main issues. Now, Lordship, I will come to page 22, where the principles laid down in this.
Page, not page,
Oh, sorry,
para,
sorry,
para 20.
para 22. The principles laid down in this case. Para 22. According to the accepted canons of service jurisprudence, seniority of a person appointed must be reckoned from the date he becomes a member of the service. The date from which seniority is to be reckoned may be laid down by rules or instruction. A, on the basis of date of appointment. B, on the basis of confirmation. C, on the basis of regularization of service. D, on the basis of length of service or any other reasonable basis. It is well settled that an ad hoc or fortuitous appointment on a temporary or stopgap basis cannot be taken into account for the purpose of seniority, even if the appointee was qualified to hold the post on a regular basis. This is my. Now, Lordship, I will come to the particular rules. Directorate Service Rules 1973. In Schedule 1 of that particular rule, it is clearly stated that Direct Development Department is have to follow this rule. Schedule 1 of that Directorate Establishment Service Rule 1973.
Just a minute.
In serial number 54, Director of Dairy Development, it is come under Secretary Veterinary.
Just a minute, just a minute.
Yeah.
Yes,
Yes, Lordship. As per the schedule of that rule 1973, Director of Dairy Development Department is to follow this rule for the purpose of promotion to grade 3 post from grade 4 post. Now, Lordship, Rule 10.
schedule is where?
Schedule.
Sched-
Schedule is at page 183 of Assam Service Manual. Serial number 54. Schedule 1, serial number 54.
Just a minute, please. Director of Dairy Development.
Yes, Lordship. Yeah. 54 serial number. So Director of Direct Development have to follow this rule in the case of promotion from grade 4 to grade 3. Now rule 10. What rule 10 says, Lordship? Rule 10 about junior assistant appointment shall be made by appointing authority by direct recruitment nature. By direct recruitment.
Yes.
Direct recruitment. Now, Lordship, directly come to sub rule 3 of rule 10. It is said by selection on the basis of suitability from amongst the grade 4 staff of the office who possesses a bachelor's degree from a university recognized by the government and also possesses such other qualification as laid down in sub rule 2(3) of rule 12 and have rendered not less than 7 years of continuous service in the office on the first day of the year on which the selection is made. Now, Lordship, second proviso is important. Provided that the number of vacancies to be filled up in any year according to the sub rule 3 shall not exceed 10% of the vacancy. Now, Lordship, as per this rule,
Where is the proviso?
proviso to sub rule 3 of rule 10, provided that the number of vacancies to be filled up
Yes,
in
sir.
any year according
There is no
to the
proviso.
sub rule 3 shall not exceed 10% of.
Which book are you reading?
First, I am reading this book,
Page?
page 175.
Where is the proviso? Notes are there.
No, Lordship, it is amended in 2016. Perhaps Lordship is reading the earlier edition of that book. It is the latest edition. Lordship, they have also enacted the.
Same book you are holding.
Lordship, I have also bought it from the library.
Which page? To 175.
175, Lordship, page
10.3.
10(3).
Thereafter, notes are there. Note 1, note 2, note 3.
Lordship, they have also enacted the amended rule.
Okay, 10%. That is not in dispute. Okay. 10%. That is okay.
10%, 10%.
Yes.
Lordship, now, at that particular time, there was vacancies of 16 number of posts in grade 3. Now they can promote from grade 4 only 10%. 10% equivalent to 2 number of posts.
Yes.
Now, Lordship, another important rule is of 12, rule 12. 12, sub rule 3, page 177. Educational qualification regarding relevant for promotion from grade 4 to grade 3. Required educational qualification.
Yes.
It is stated, for appointment to the post of junior assistant, a candidate must possess a bachelor's degree from a recognized university or
You're reading rule 12. Which one?
rule 12, sub rule 3, Roman 3, at page 177.
Now, is there any dispute regarding qualification?
Lordship?
Is there any dispute regarding qualification?
Yes.
There is a dispute.
There is no dispute.
Then why are you reading
Uh,
this?
Lordship, so I am my submission to this particular rule
He
is
has
that.
He has not made any allegations that you are not qualified.
Oh, yes, sir.
He has made 4 points which you have paraphrased.
Yes,
You
sir.
have to address on those 4 points.
Yes. Lordship, now, my humble submission is that when the relevant rule is followed in its letter and spirit,
That you have already said.
yes, sir. Now,
No, before you have reiterated this, but don't you think that your first submission is contrary to what Madam has said? Madam said the 73 rules are not applicable.
yes, but rule itself tells that the rule is applicable in the direct department.
No, diary department is a different, it's a general concept. She says that these posts, as you have also admitted,
Yes, sir.
are supernumerary posts,
Yes, sir.
personnel posts.
Yes.
Here, the rules, application of the rules will not be there, and this is the department's version. If
Yes.
department says, then we'll go by the department in which rule will be followed.
Yes. But Lordship, I want to go to one annexus of the retreat. in a communication in the year 2013,
Page
page 59.
of the writ petition.
Yes, Lordship. Annexure 7. It was communicated by Deputy Secretary to the Government of Assam Animal Husbandry and Veterinary Department to the Director, Animal Husbandry and Veterinary Department. Subject is consideration and approval for promotion to the post of next higher post.
Just a minute, please.
Now, with reference to the subject cited above, I am directed to reproduce the Finance Department endorsement as below. The
Yes.
Veterinary Department is informed that after regularization of service of workers and master roll workers, the incumbent concerned, that is regularized workers and master roll workers, are eligible to get all benefits like other government employees, including promotion as per prevailing government policy, rules, acts, instruction, etc. And if necessary, by issuing necessary OM, executive orders, etc. Now, at that point of time, what rule was applicable? It is the question. 73 rule was applicable, Lordship. So do I have to follow that rule? And Lordship, if we go to the minute, then the language of the minute and remark also follows that instruction of the particular rule, Lordship.
Mr. Pathak, you are appearing for a private respondent.
Yes, Lord.
Your interpretation as which rules are applicable, we will not accept that.
Yes.
It is the department.
Yes.
Department is the prerogative of the department. If we find that the wrong rules have been applied, then that's a different matter.
Yes.
But that is not neither his case nor your case.
Yes, Lord.
Your case is that seniority doesn't have a role here.
Yes.
Number one.
Yes.
Neither the rules nor any norms say that seniority has to be given a preference.
Yes.
And you are regularized on the same date.
Yes.
The only rule or norms which can be called out is one part where suitability point has been emphasized.
Yes, Lord.
And your suitability has been found that you have remarks of outstanding and excellent, whereas he has very good.
Yes.
That is your point.
Yes.
Mr. Ahmed,
Lordship, kindly see the page 3 of their affidavit and report.
of the department.
Department. PL number 17,
Just a minute, please. Page?
page 3. Internet page,
Yes, yes.
page 70. With regard to statement paragraph 18 of the report denied the contest of the PITA. Selection did not contravene any rule. The minor selection dated 1610 to 2000 pertaining to selection of post as well, covered by all aspect criteria for selection, including the case of regular staff. I am also a regular staff. Service rule will prevail. Gradation list, I am above to the private respondent. ACR has never been communicated to me after regularization. My lord, a special report that has been given by them, I don't know. Recommendation of controlling officer. Gradation list, ACRs also to be looked after, my lord. ACR, whether any adverse or anything has communicated to me, that is now a mandatory after Dev Datta case, my lord. They said that gradation list is not applicable in this, but in their written statement, they state that gradation list is applicable. This is the case. Recommendation, I have nothing to say, my lord. Controlling of.
No, Mr. Ahmed, you know very clear, when the criteria would have been promotion on the basis of seniority,
Yes, my,
then gradation list would have had a very pivotal role.
yes,
Now here, the role of the gradation list only to have the numbers of candidates within the zone of consideration.
yes, yes.
Now 16 numbers of vacancies were there. 10% would be at most be two numbers. Of.
Yes.
So persons were considered, you were also considered, he was also considered. He was found to be more suitable on the
Yes.
basis of certain documents which have been placed on record.
Yes.
Placed before the court, not on record. You may be correct that ACRs ought to have been communicated to you. Devdutt's
Yes.
mandate is, it's a mandatory
After that also,
requirement.
yes.
Even ACRs which are good, those also have to be communicated. It's not
Yes.
that only adverse
Yes,
ACRs needs to be
yes.
communicated. But that itself, will it affect the promotion of the S1 5?
And their replies that to be considered.
No,
by ACR.
will that be enough to interfere or give a handle to the court to interfere with the promotion of the S1 number 5?
No.
Will it be a ground for interference?
Interference, Lordship, that.
What is your age?
Now I am retired the 31st March,
You're retired
retired
yesterday.
yesterday.
And Mr. Pathak,
I have another service of almost more than 7 years of 80.
I think you have put much more effort than is required.
Minor six.
Let us pass the judgment.
And on to national benefit, my something.
Okay. Heard Sri A. Ahmed Learned Counsel for the petitioner. Also heard Sri M. Kotoki Learned Standing Counsel, Veterinary and Animal Husbandry Department. Whereas the private respondent number 5
Yes, but M. Patel.
is represented by Sri M. Pathak Learned Counsel. Full stop. It is the promotion of the respondent number 5 as
Junior assistant.
junior assistant in the Department of Animal Husbandry and Veterinary, which is the subject matter of challenge in this petition. Full stop. Para. According to the petitioner, comma, he was initially engaged as a mastoral worker
Master local.
in the department on 1/10/1986.
Yep.
Whereas the respondent number 5 was engaged engaged at a later point of time on 1/10/1992. Full stop. Both the petitioner and the respondent number 5 were, however, regularized by an order dated 30/9/2005 in the establishment of the Deputy Director of Dairy Development within bracket Zonal Nalbari. Full stop. On such regularization, comma, the petitioner, the parties were to be considered for further promotions subject to fulfilling the criteria laid down. Full stop. In the meantime, comma, a gradation list was published wherein the petitioner was placed against serial number 37, whereas the respondent number 5 was at serial number 128. Full stop. The petitioner also claims to have participated in a training program and various documents have also been pressed into service to contend that the petitioner was entrusted with additional duties pertaining to grade 3 post. Full stop. On 16/2/2018, comma, the selection committee held a meeting, and in the said meeting, comma, the respondent number 5 was selected for appointment to the post of junior assistant. Full stop. It is this exercise which is the subject matter of challenge, comma, as indicated above. Full stop. Para. Sri Ahmed, the Learned Counsel for the petitioner, has submitted that the Assam Directorate Establishment within bracket Ministerial Service Rules 1973 had undergone an amendment on 27/9/2016, as per which the eligibility criteria for promotion from grade 4 to grade 3 has been laid down. Full stop. As per the amended rules, comma, there is a requirement to serve in the feeder cadre for a minimum period of 7 years. And the educational qualification is to be a graduate, and the candidate is required to fulfill Rule 12 within brackets small Roman 3. Full stop. The percentage fixed for such promotion to the post of grade 3, which is otherwise a post to be filled up by direct recruitment, is 10%. Full stop. The criteria for promotion has been laid down as suitability to be assessed. Full stop. By drawing the attention of this court to the impugned minutes of meeting dated 16/2/2018, comma, Sri Ahmed, the learned counsel for the petitioner, has submitted that the remarks column does not specify any details as to how the respondent number 5 was selected over the petitioner. Full stop. He has also drawn the attention of this court to the order dated 5/3/2024, whereby the learned counsel for the department was directed to produce the comparative statement of the parties to the list. Full stop. Para. It is also submitted on behalf of the petitioner that remarks in the ACRs were never communicated, which is mandated by the Honorable Supreme Court in a caten of judgments, including the landmark case of Devdutt versus so-and-so, reported in so-and-so. Full stop. He accordingly submits that the impugned promotion is liable to be interfered with. Full stop. Sri Ahmed, however, fairly informs this court that his client has attained the age of superannuation yesterday, i.e. 31/3/2024, and therefore he may be granted notional benefits pursuant to such promotion if this writ petition is, in the event this writ petition is allowed. Full stop. Para. Per contra, comma, Ms. Kotoki, the learned standing counsel, has opposed, has contended that the promotion was made by following the due process of law and in a transparent manner. Full stop. By referring to the affidavit in opposition, which was filed on 4/12/2018, comma, the learned standing counsel has submitted that since the posts held by the petitioner as well as the respondent number 5 in grade 4 are supernumerary posts which were personal to the parties, comma, the rules of 1973 per se would not be applicable. Full stop. However, the promotion was considered on the basis of continuous service, special reports, and a recommendation. Full stop. She has also pointed out that the date of regularization of the parties being the same, comma, the parties were at par in terms of their consideration. And in any case, seniority does not play any pivotal role in the matter of promotion. Full stop. She clarifies that the graduation list is only to ascertain the date of retirement and not for the purpose of any seniority. Full stop. The learned counsel has also placed before this court the comparative statement of the parties and the special report oblique remarks as per which the respondent number 5, now as per which the respondent number 5 has been termed as excellent, outstanding, whereas the petitioner has been termed as very good. It's of inverted mid-digit. The learned counsel for the department has otherwise pointed out that since the petitioner has already superannuated from service, no effective relief can be granted to the petitioner, even if any case for interference is made out. Full stop. Para. Sri Pathak, M. Pathak, learned counsel for the respondent number 5 has submitted that affidavit in opposition has been filed on 14/11/2023, and the promotions being made strictly in accordance with the rules, and there being no allegation of any such violation, those would not come for any interference by this court. Full stop. As regards the qualifications and additional works done, as claimed by the petitioner, Sri Pathak clarifies that his client has got the same qualification and has also rendered additional works pertaining to grade 3. Full stop. Though it is submitted that the regularization was done on supernumerary post, which should be abolished after the retirement, by drawing the attention of this court to a communication dated 12/3/2013, it is submitted that such incumbents would be entitled for consideration for all service benefits, including promotion.
Okay. The post is abolished not only on retirement, but in any manner. Suppose my candidate is, yes, sir.
Para. So far, though there is no, Sri Pathak has also placed reliance upon the case of Ashok Kumar Gulati versus so-and-so, reported in 1986, supplementary SCC 424, wherein it has been laid down that ad hoc period of service would not be taken into account. Full stop. Paragraph 22 of the sage judgment has been pressed into service, as per which seniority is to be reckoned from the date when one becomes a member of the cadre. Full stop. Sri Pathak has also relied upon the provisions of the rules, namely Rule 10 of the Assam of the rules of 1973, and submits that there being 16 numbers of vacancies, 10% would constitute two numbers of posts which were duly filled up by the respondent number 5 and another incumbent. Full stop. Para. 3. Ahmed, the learned counsel for the petitioner in his rejoinder, has submitted that it is for the first time when the remarks in the ACRs have been learnt by him on the report being placed before this court. And the ACRs and the ACRs and the remarks of the ACRs not being communicated, such ACRs could not have been acted upon for the purpose of promotion. Put the para. The rival submissions made by the learned counsel have been duly considered, and the materials placed before this court have been examined. Full stop. The challenge by the petitioner towards the promotion of the respondent number 5 wide the minutes of meeting dated 16/2/2018 is primarily on the ground that the petitioner is much senior in service, as he was initially engaged on 110/86, whereas the respondent number 5 was engaged on 110/1992, both as master roll workers. Full stop. The petitioner has also emphasized that such seniority is also reflected in the gradation list, in which the petitioner has been placed against serial number 37, whereas the respondent number 5 has been placed as serial number 128. Full stop. The para. This court has looked into the rules of 1973 regarding the recruitment to grade 3, which is normally to be filled up by direct recruitment, and only 10% is to be filled up by way of promotion from eligible grade 4 employees who fulfills the criteria laid down. And such promotion is on the basis of suitability. Full stop. Para. There is no provision in the rules that seniority would have any role in the manner of promotion. Full stop. That being the position, the rival contentions as pleaded in the writ petition as well as the affidavit is required to be seen. Full stop. The petitioner has pleaded that additional duties in the duties of grade 3 post were entrusted to him. Full stop. However, such duties were also performed by the respondent number 5, which in any case would not have which would not be a deciding factor in the matter of promotion. Full stop. Though a contention has been made on behalf of the department that the rules of 1973 per se would not be applicable, the spirit of the rules would be applicable, wherein a transparent and fair manner is to be adopted for making such promotion. Full stop. The comparative statement placed before this court would show that while deciding the aspect of suitability, comma, as per the comparative statement, comma, the special report of remarks, qua, the respondent number 5, comma, as noted above, is excellent, comma, outstanding, whereas that of the petitioner is very good, full stop. Though Sri Ahmed would be right in contending that the remarks in the ACRs ought to have been communicated to him, comma, the same would, however, would not have much bearing in the adjudication of this case, full stop. When the records placed before this court clearly reflects that the remarks of the respondent number 5 was higher than that of the petitioner, and both of them were considered in the promotional exercise made by the selection committee in the meeting dated 16/2/2018, comma, there remains hardly any scope for interference with the aforesaid promotion. Full stop. This court has also noted that the petitioner has in the meantime attained the age of superannuation. Full stop. Para, in view of the above, comma, this court is of the considered opinion that no case for interference is made out, and accordingly, the writ petition is dismissed. The documents placed before this court by Ms. Kotoki, the Learned Standing Council, are made part of the records.
The compensation is also there. Officer, the one is, or a recommendation from the consulting officer is also there. It's the
Yes. I've seen that. Two annexures are there.
Elector and
Okay.
with you.
Do you have copies of this, madam, or you want to have photocopies? You have copies, otherwise you don't have.
Online.
Alright.
I did file.
Lordship, last occasion, on several occasions, this matter was heard, no affidavit was filed, my lord. Subsequently, just now they filed a affidavit copy as is
Today,
today, just now. A date may be given on May.
What is the
on
matter,
May 2nd,
Mr.
my lord.
Lordship, during the course of the day, we are filing the affidavit. Lordship, we have already,
no, that is okay. What is the subject matter?
Subject matter is, I am not considered for promotion. My junior was promoted.
As promotion as,
As a director of food and civil supply, deputy director or superintendent food and civil supply.
what is your age?
My age is, I am retiring on August, my lord.
Okay, madam, when can we have? When can we have?
Lordship, after 2 days, Lordship.
When can
After
we have?
2 days,
Tell us.
I have to file and reply, my lord.
Okay,
So May 2nd, my lord,
2nd May.
2nd May. Today is
2nd
the
May.
1st April, my lord.
You want 1 month to file reply?
No, my lord, there is a vacation, my lord.
Vacation is good. You utilize the vacation.
My lord, I can file, my
File it on 18th. We'll have it on
I do
23rd.
not require any time, my lord. Lordship may give any time, my lord. I am just a convenience of the court, my lord.
On 9th,
On 9th, my lord.
9th April.
My lord, there is a problem, my lord. On 10th April, there is a Eid, my lord. The this vacation list is not,
No, we are having on 9th, not 10th.
my lord. Who knows, my lord? It will be holiday on 9th and 10th. Earlier on twice, 2
Uh,
days has been given as
Let
a
us,
holiday
let us
for
have it,
Eid.
let us have it. Let us say 10th is
That,
there. We will have it on 9th. You file your affidavit immediately.
my lord, just a minute, my lord. Let it be on 8th, my lord.
Next Monday.
next month.
You file it then. Third, Sri D.N. Bhattacharya, learned counsel for the petitioner. Para. Ms. A. Talukdar, learned state counsel, submits that the affidavit in opposition would be filed during the course of the day. An advance copy of the same has already been handed over to the learned counsel for the petitioner. Full stop. Para. Let such affidavit be tagged with the records. Full stop. Let this matter be listed as agreed to by the parties. Let this matter be listed for admission hearing on 8/1/2024, by which time, the petitioner may file rejoinder affidavit.
Keep your black.
Item 6.
May it put your lordship. It's a land acquisition matter, my lord, 2018 matter, my lord.
Land acquisition.
Yes, my lord.
Yes, what has happened?
Earlier honorable court has ordered, but they are asking for time, my lord. Time like one more.
Lordship,
There is
we
a
have
paper
for
in that.
respond number 4, Lordship, we have filed one affidavit, but inadvertently, Lordship, in the cost title additional easement, so.
Doesn't matter.
Lordship, this is affidavit.
Doesn't matter. Can we go for disposal today?
Then- Yes, my lord. But she was requesting for 2 weeks time in the outside matter. I
I
don't
am
know.
for respond number 1, madam.
One is revenue
Yes,
department.
madam.
Yes.
I need some time, I don't.
Why? 19 matter from 19 to 2024, 5 years you did not have time.
I not, the file was misplaced.
So many times time were taken.
Madam, it doesn't look good if you take time of 19.
1 week, my lord,
15,
I will
madam.
put the.
1 week, okay,
Not
1
1 week. We'll have it on Thursday.
My lord.
Thursday. Very good.
19, 18 matters, these are,
Yes,
you have to finish these matters off.
so many times it's been listed, but they're taking.
Oh. Heard. MSN Saike, learned counsel for the petition. Full stop. Also heard. Miss M. Bhattacharya, learned state counsel, as well as MS PR Mohanta, learned counsel for the revenue department. Full stop. Though the respondent number 4 has filed the affidavit in opposition, Ms. Mohanta, the learned standing counsel revenue has paid for some accommodation. Full stop. Para. Considering that the petition is of the year 2019, a short accommodation is granted, directing listing of this matter on Thursday. 4th, 4. 4/4.
Obliged.
Obliged.
Item 7.
What is this?
My lord, in the meantime, during the pendency of this petition, my lord, the petitioner retired from his service on 31/8/2021. So probably, my lord, your lordship will kindly see the relief sought for by the petitioner. I have mentioned in the synopsis as well as in the, at page 43, your lordship will find the where in the synopsis also I have given in the paragraph number 1. So basically, 3 reliefs were sought, my lord. Denial of promotion to the petitioner from the post of senior manager civil to the post of deputy manager civil, to which the petitioner had become eligible and entitled since 1/7/2009. And he has now been superannuated on 31/8/2021
Mr. Sanapati for whom?
for NAPCO.
NIPCO.
Affidavit has been filed, but
Yes.
it's a short issue, your lordship can dispose it of.
Now, what is the remaining relief?
My lord, B especially, the denial of retrospective benefit of promotion to the petitioner in the rank of manager civil, to which he was promoted after a delay of more than 2 years. For that, he may have some financial benefit. And number three is denial of monetary benefit of the next higher post of deputy general manager to the petitioner on completion of double the eligibility period prescribed for promotion to
When
that
did you
higher post.
retire?
Well, I retired on 31/8/2021.
21, okay. Pending since 19, okay. Let's
Yes.
try to finish this off. What?
Yes. At the time of retirement, my lord, on 31/8/2021, the petitioner was serving as a senior manager civil,
31/8/21, you have retired.
retired. At the time of retirement, I was serving as senior manager civil under Northeastern Electric Power Corporation Limited, NAPCO,
Serving as senior manager,
within bracket civil,
okay, in NIPCO.
NIPCO, and was posted at Kamen Hydroelectric Project in Arunachal Pradesh.
Okay,
Now, so far the petitioner is concerned, my lord, he belongs to the scheduled caste community and he joined the NAPCO on 30/5/1998.
30.
30th of May 1988 as SDO civil.
Yes,
Then he was promoted on 3/9/1996 as executive engineer, assistant manager.
executive engineer.
Yes. But then he became eligible for promotion as deputy manager on 1/7/1998.
Executive engineer and senior manager are same rank.
No, senior manager different.
No, executive
So
engineer.
after executive engineer, within bracket, within bracket assistant manager.
Assistant manager.
Right. Then, my lord, he became eligible to be promoted as deputy manager on 1/7/1990. Only 5-6 dates.
17
1998.
became eligible for,
On 1/7/1998
eligible for
as deputy manager.
promotion to deputy manager.
Manager.
Okay,
Although, my lord, he was eligible for promotion on deputy manager, but he was promoted on 27/3/2002 and with retrospective effect
as deputy manager.
as deputy manager. With retrospective effect from 1/7/1998.
So there is no dispute regarding that.
No. Now your lordship will come. Then, my lord, he became eligible for the next post, that is manager civil, on 1/7/2001.
He became eligible.
Eligible. Then, although I became eligible on 1/7/2001, unlike
Eligible for promotion to,
manager, within bracket civil.
okay,
Now, although I became eligible on 1/7/2001, my lord, there was delay in holding the DPC. And ultimately, I was promoted on 29/7/2003 as deputy manager, manager civil.
27/9,
29th of July 2000,
29/7,
29/7. But here,
2003,
but
promoted.
promoted. But here, that retrospective benefit has not been given. Now I need,
Not given.
not given, but now I need to answer to your lordship also. I filed this writ petition in 2019 and this benefit was accrued on 2003. After 16 years, how can I claim? I have to address your lordship because ultimately, if I sleep over my rights and if there is delay and lashes in approaching this honorable court, I can be thrown at the threshold. I cannot say that I have filed a representation or I have been filing repeated representation to have this benefit. This is one your lordship will keep it in mind. But if I have an explanation for this delay, then your lordship can consider. That is, there is no dispute in regard to that. Then, my lord, on joining the post, my lord, as manager civil, he claimed retrospective benefit by representation on 25/8/2003.
25.
8/2003. Your lordship will just take note.
You sought,
This retrospective benefit I sought because there was a gap of around 2 years. That representation your lordship may not look into, but your lordship will kindly take note of the page number is 223 and Annexure 39. Now, against this representation, my lord, the management submitted a reply. That reply was given on 8/11/2004. That means representation was of 25/8/2003, and the reply was given on 8/11/2004. That your lordship may find at Annexure 41 at page 225.
Yes, rejected.
Rejected means the management took a stand that the promotion was delayed due to the pendency of a court case. A writ petition was pending, and therefore this benefit could not be considered at that time. Then ultimately on my lord 10/8/2006,
Yes.
he became eligible for senior manager civil. Oh, sorry.
He was promoted.
He was on 10/8/2006. He was promoted as senior manager civil,
Promoted.
but he became eligible for the same since 1/7/2004. 2 years gap is there.
Let us write 1/7/2004 first, 1/7.
1/7/2004, he
became
became
eligible.
eligible for senior manager civil, but was promoted on 10/8/2006.
Promoted on 1/8/10/8.
10/8/2006. So as per their service rule, my lord, the next post for him was post of DGM, which he would have become eligible on 1/7/2009. He became eligible on 1/7/2009 for the post of DGM, Deputy General Manager.
Yes.
My lord, since I became eligible for the post of DGM on 1/7/2009, from 1/7/2009, I appeared in 5 DPCs. The 5 DPCs were held on 2/3/2012,
Okay.
then 34/2014, then 25/6/2015, and 17/3/2017, and 27/6/2017. But he was not recommended for promotion. The reasons were never disclosed. He was always failed in the interview. And of course, he has taken a ground that so far NAPCO is concerned in this type of situation, it was always the ST candidates they had prepared. There was none from the scheduled caste who was promoted. That was one of the discrimination he has pointed out. Now, so far the third relief is concerned, my lord. Denial of monetary benefit of the next higher post of Deputy General Manager to the petitioner on completion of double the eligibility period. My lord, this relief number 3, he is seeking this relief in terms of rule 13.2.2.
Where do you get this?
I'll come. Your NAPCO rules is there, my lord. I'll come to that. 13.222, the post that for which this Deputy General Manager, that is a E1 post. E1, they call it E1. E1. Ours is, sorry, I'm sorry, ours is E6. E6.
General Manager.
Deputy General E6 post.
E6. E6. Now they say that this
We are Deputy General Manager is E7.
sorry, we are at E6, Deputy General Manager is at E7. It's there.
E7 post.
E7 post. The rule which, on the basis of which we had claimed, that is 13.2.3, that is 13.2.2, they say that this cannot be granted to you because this benefit can be given only to the post of E1. And against that, my lord, they have quoted that portion of the rule at page 63 of the affidavit in opposition filed by the NAPCO. So basically, my lord, if your lordship will see that there is a delay of, in one circumstance, it's delay of 16 years if I count it from 2019. In another case, it is 13 years. Basically, what the grievance that has been given in the writ petition is that there were a lot of queries during the RTI queries were made. Subsequently, he appeared in the DPC and all. They were assuring him. Only those explanations are there so far the delay is concerned. And DPC was also not conducted
No,
on
Mr.
time.
Quar, that issue is there, but so far as the relief number 3 is concerned,
Yes, madam.
that we can most probably we can examine objectively because
Yes.
they say that your reliance upon 13.2.2 is incorrect.
Incorrect.
It applies on E1 post only.
Yes, madam.
And you were in a E6 post,
Seeking promotion to E7.
seeking promotion to E7 post.
But I have completed the qualification
No, no,
criteria.
do you have any materials to show that 13.2.2 would be applicable even for a E6 to E7 post?
Oh, I can't.
If that is not there and those provisions of the rules are not the part of challenge.
I have to be fair to as an officer of the court.
No, since this can be examined or scrutinized objectively.
Yes.
One
And-
rule is applicable, you said this is not applicable.
But
If-
subject, my learned friend can also assist us in this aspect. But so far my knowledge is concerned, he is the basic grievances during his entire career. He has been
No,
discriminated.
so far as relief number 3 is concerned,
Yes, madam.
apart from reliance upon rule 13.2.2, do you have any other grounds of seeking relief number 3?
I'm afraid, my lord, I don't have. Except this now, to some extent it's survived, but there is a delay. So, but the delay is not attributable to the petitioner alone. Delay is, they have also not hold the DPCs and time and all. And in one instant, you also have seen that they have given him the retrospective benefit. And in the other cases, in the second time, they have not been given. And on that second time also, my lord, the ground taken was that due to the pendency of the writ petition, where I was not even a party and no relief was sought against me. Those materials are also not disclosed to me. So let my learned friend Mr. Senapati submit, my lord, subject to what he says, then we may be able to reply to it. But that sequence, your lordship will find it in the synopsis also.
Okay, Mr. Senapati.
Your Lordship, my learned senior has already submitted it with regard to the delay. We have already communicated our decision way back in 2004, and my learned senior has already referred to that document. Your Lordship may just see once more that at page 225.
225.
That is relating to retrospective from. With regard to relief number 1,
Just a minute, please. 225 is your letter.
yes, in reply to
811.
811. I'm directed to refer to your letter to the above. You that representative was examined and put up to the competent authority. However, competent authority have not agreed to extend the retrospective benefit of promotion in the cadre, and accordingly the decision was communicated to him through general manager dated 7/6/2004. It may be pointed out that the delay in promotion from AMC to DM and manager was occurred due to the court case filed by some AMC challenging the seniority of AMC, and that judgment of the court was given on 23/2003, after which the promotion of Sri Das, along with others who were promoted provincially by promotion order, was regularized with effect from 5/5/2003. After publication of the final seniority list, he, along with other eligible deputy manager, were considered for DPC for promotion, and as approved by the competent authority, they were promoted with effect from 9/7/2003. Accordingly, Sri
tasked as joined on promotion as manager C without raising any grievance regarding effective date of promotion. As such, the representation submitted by him at this belated stage claiming retrospective benefit of promotion in the cadre of manager C is not tenable at present. Because your lordship now, even assuming your lordship don't go into the question of the delay, the other people who will be affected by the entire granting him this relief, those are also not party in this proceeding. And to undertake that exercise now after he has superannuated, so retrospective promotion. Yeah. The first relief to director give promotion to that he already have got it, your deputy general. Now comes to the third one.
Now only the monetary benefits he can.
That your lordship will have a look at the clause. The clause is at page 107,
Which clause?
that 13.2.2.
107.
Aman,
267, your lordship will find that, huh? 13.2.
Our affidavit, your lordship.
Page 67. 267.
257. Your lordship may just refer to the internal page 107.
We have got this. 267 is the running page. Yes, we have got this. Manual.
There your lordship may just see 13.2.2.
Yes.
Now, if I may read it, your lordship, it might not be possible to ensure advancement career prospect beyond certain point for employee for the higher post for want of vacancy or requirement in the higher group cadre. Such cases shall be reviewed and employees may be considered for the higher grade subject to completion of double the eligibility period prescribed for the promotion to the higher post and subject to fitness. Such cases will be screened by PNA and will be submitted for approval by competent authority as mentioned in Rule 15. However, the employees will get the monetary benefit of the next higher post, but not the designation which will be against the vacancy only. Now, there was a board resolution way back in 25/11/2009 that your lordship will find at internal page 61.
Your affidavit.
In my affidavit.
61. Yes, yes.
Now, this was brought about, the change that has been brought about, modification, your lordship may see. The benefit of a scale of next higher grade will be allowed to all employees who are stagnating for more.
You're reading which one?
The page 63, internal page of my affidavit.
63. 63? Yes, which part?
The modification
Yes, the
in the
benefit.
column. The benefit of a scale, your lordship, am I?
Yes, yes.
The benefit of a scale of next higher grade will be allowed to all employees who are stagnating for more than double the eligibility criteria as applicable in the highest grade as a one-time measure in the entire service career, irrespective of their qualification and channel of promotion. This benefit will, however, be applicable only to employees of workman cadre, supervisory cadre, and executive cadre up to E1 grade. This was brought about on 25/11/2009. He became eligible for this promotion only on 1/7/2010. that prior to he became eligible, this rule was already amended. Therefore, this monetary benefit he is not entitled to. Because he is above T1, is E6.
When did he become eligible?
He became eligible on 1/7/2010. And this, even assuming he is entitled to, he ought to have a
1/11?
1/7. 1 July 2010. And he has not challenged that.
No, that part Mr. Kaur has fairly
Yes, Your Lordship, I will not.
he has considered that it's up to E1. He is in E6.
Yes.
Aspiring to become E7. Okay. Anything
That-
else?
Nothing. Because now,
Only I'll add, this contention was taken in their affidavit in paragraph number of 46, 47, and 48. And we have given a reply. Your Lordship, it's not that they are strictly following that rule. We have given an explanation in our affidavit in reply in paragraph number 29. That they, in spite of this, my lord, other persons were given the benefit, my lord. Your Lordship will take note of their paragraph 46, 47, and 48 in their affidavit in opposition in regard to 13.2.3. Now, against that, we have given a reply in paragraph number 29 in our reply. Your Lordship may kindly look into. Because some explanation has been given. my lord. And in regard that, your Lordship will also look at paragraph number 49 of the writ petition. I'll just read it, my lord, paragraph number 49. My lord.
What has been said?
Well, the petitioner has learned that by a resolution passed by the Board of Directors of NIPCO in 2009, the aforesaid benefit was stopped. However, the petitioner stated that many diploma cadre engineers were given the said benefit even after 2009. The case of one Sri Dilip Kumar Short, Deputy Manager, Civil Engineer, E4 is an example to the point. By Office Order number 101 dated 6/7/2011, he was granted the benefit of higher pay scale of the next higher post of Manager Civil Diploma E5 plus all other admissible allowances with effect from 1/1/2001. In their affidavit in reply, my lord, in paragraph number of 46, 47, they say that the diploma engineers were given by simply saying that as a special case. And we have said, my lord, again, in paragraph number 29, I'll read it slowly, my lord, that with regard to the statement made in paragraph number 46, 47, and 48 of the counter, the deponent begs to reiterate the statement made in paragraph number so-and-so of the writ petition. Further, the deponent states that Sri Dilip Kumar Shaw, Deputy Manager Civil, was given the benefit of highest pay scale of the next higher post of Manager Civil E5 with effect from 1/1/2011 by the Office Order number 101 dated Shillong, the 6th July 2011. Many diploma engineers were also given such benefit. The respondents have contended that the rule for allowing benefit for double the criteria was modified on 25/11/2009. But from order dated 6/7/2011, it is seen that double the criteria was allowed for Sri D.K. Saud on 6/11/2011. Thus, there is a contradictory contention on this issue, which NAPCO could not satisfactorily reply. Again, in paragraph number 47, the respondents have stated that as a special case, some diploma engineers were allowed the benefit. Thus, the reply of the respondents are totally so-and-so. So it's not that it's a rule which have been strictly followed in case of all.
Yes, Mr. Senapati, how do you,
Your Lordship, we
after
say
the modification, you have still given benefits to some.
some as a diploma. Your Lordship may just look at my paragraph 47, if I may
Please
just read.
read.
It is stated that though the benefit under clause 13.2, that is extending the higher scale, was restricted to level E1 only through a resolution passed by the Board of Directors 25/11/2009. As a special case, few diploma engineers were extended the benefit of the double of the criteria benefit. However, such singular instance have now completely stopped. In this context, it is pertinent to state that it may be noted that the clause 13.2.3 does not replace clause 13.2.2. In fact, clause 13.2.2 is a subsequent edition approved by the Board of Directors in its 170th board meeting dated 25/11 and as circulated White Office dated 3/12/2009, which was effective from 1/1/2010. The clause 13.2.2 extend the benefit of next higher scale to employees who are stagnating in the same scale for double the prescribed eligibility criteria due to want of vacancy. Although he possesses the prescribed qualification to be promoted and there is a channel of promotion. Next, as explained above, the Board of Directors in its 170th board meeting added the clause 13.2.3 to grant benefit of higher scale to employees who do not have COP and prescribed qualification to be promoted to the next grade, but with a restriction that this benefit under clause 13.2.3 will be extended only up to the level of E1. Therefore, the clause 13 still exists to facilitate the benefit of higher scale beyond it subject to availability of COP and prescribed qualification. However, during 2012, the management reviewed the matter of extending higher scale benefit and decided that it would be prudent to extend the benefit up to the level of E4 only under clause 13.2.2, since allowing this benefit beyond E6, promotion from E5 to E6 is within the group sanction, and there is no question of want of vacancy, would amount to creation of a post in the level of E7, which is beyond the DOP of CMD. As a one-time measure, it was there, but it was done only up to the level of E4. And for people of the diploma engineer, not graduate engineer, because they don't have a promotion scope beyond that level. He is not a diploma engineer, you know.
Our case is also similar like so. For promotion where I was eligible, the qualifying service was required was 6 years. I retired in 21. 15 years I worked in the same post. 17 years to be precise. I worked in the same post in stagnant. So there
Why
is no.
DPC couldn't be held and
No,
promoted?
Mr. Moore, there would be a difference where because of lack of any promotional avenues, you are stagnating. Here you had participated in DPCs.
Yes.
You had participated.
Yes.
You are found to be not.
Yes.
That's
More than 5 times. And
yes.
discriminate.
And those rejection or whatever non-consideration are not the subject matter
No.
of challenge.
So see.
Stagnation benefits, stagnation increments, whatever you call in the different service jurisprudence, these are only to give an incentive to certain posts where there is no promotion avenues at all. Not for posts where you had appeared, you did not qualify.
But in the meantime, my lord, that qualification, that double the criteria, that 6 years I have completed. And for 17 years, I worked in the same.
Okay.
That's the issue. Everyone should go home, then all the points have been placed before the court. And after that, they resolve.
The present petition under Article 226 of the Constitution of India has been filed with the following relief. Quote, para. The petitioner was an officer of the NIPCO and had retired from service on 31/8/2021 as a senior manager within bracket civil. Full stop. The petitioner, who belongs to the scheduled caste community, had joined the organization on 30/5/1988 as SDO bracket civil and was subsequently promoted to the post of executive engineer within bracket assistant manager on 3/9/1996. Full stop. It is the case of the petitioner that though on 1/7/1998, he had become eligible for consideration for promotion to the next higher post of deputy manager, comma, he was given such promotion on 27/3/2020. However, with retrospective effect from 1/7/1998. Full stop. Subsequently, on 1/7/2001, comma, the petitioner claims to have become eligible for promotion for the post of manager within bracket civil. Full stop. However, there was delay in holding the department promotion holding the DPC. And it was ultimately on 29/7/2003 that the petitioner was promoted to the post of manager civil. Full stop. However, comma, no retrospective effect was given. Full stop. The petitioner had filed representation on 25/8/2003 for giving such benefit, which was, however, turned down via a reply dated 8/11/2004, in which certain reasons, including pendency of court case, were cited by the NIPCO. Full stop. Para. As per the petitioner, comma, on 1/7/2004, he had become eligible for promotion to the post of senior manager civil and was ultimately promoted to the said post on 10/8/2006. Full stop. On 1/7/2009, comma, the petitioner claims to have become eligible for promotion to the post of deputy general manager and had also appeared in 5 numbers of DPC, which were held on 2/3/2012, comma, 30/4/2014, comma, 25/6/2015, comma, 7/3/2017, comma, and 27/6/2017. Full stop. However, the case of the petitioner was not recommended and no reasons were also communicated to him. Full stop. As regards the relief number 3 is concerned, comma, the projected case of the petitioner is that he is entitled to such relief as per Rule 13.2.2 of the manual. Full stop. Though there is a reply on record by the NIPCO that such rules are not applicable for the post public level held by the petitioner, comma, such benefits were given to others also, and therefore the petitioner should be given such benefits. Full stop. Para. I have heard Sri B.D. Kaur, learned senior counsel for the petitioner, assisted by Sri H. Agarwal. Full stop. Whereas the NIPCO is represented by Sri D. Sanapati. Full stop. Learned counsel. Full stop. Para. Sri Kaur, learned senior counsel, has submitted that has fairly submitted that the petitioner has retired from service on 31/8 to 2021, and therefore it is the aspect of notional benefits which he may be entitled to, full stop. As regards the delay in approaching this court qua the cause of action which has arisen in the year 2000 and before 2009, Sri Kuor, the Learned Senior Council, has submitted that there were communications made to the authorities which were also replied to. Full stop. So far as the reasons cited for not considering for the delay in holding the DPC in the year 2001 is concerned, it is submitted that in the pending cases, the petitioner was not even a party, and therefore the same could not have been a reason for delaying his promotion. Full stop. As regards, Sri Sri Kuor, the Learned Senior Council, has drawn the attention of this court to Rule 13.2.2 of the manual, qua the relief number 3, and has submitted that the said rule would that in terms of the said rule, the relief claim can be granted. Full stop. It is submitted that in spite of appearing in the DPC on 5 numbers of occasion, he was wrongfully denied of the promotion. Full stop. It is, however, clarified that such action is not the subject matter of challenge in this petition or in any other earlier petitions. Full stop. Para. It is accordingly submitted that necessary directions may be issued to grant the petition at least the monetary benefits for which he is entitled to. Full stop. Para. Per contra, Sri D. Sanapati, the Learned Counsel for NIPCO, has submitted, and by referring to the affidavit in opposition dated 23/11/2021, has submitted that the petitioner has been dealt with in a fair and transparent manner. Full stop. By referring to the reply dated 8/11/2004, which was issued by NIPCO to the General Secretary of the association, which was espousing the cause of the petitioner, it was informed that the reasons were spelled out in the said reply, which are cogent and reasonable. Full stop. Para. By referring to the manual containing Rule 13.2.2, Sri Senapati has also referred to the Board of Director meeting held on 10/7/2009, whereby there was a modification of the aforesaid Rule 13.2.2 in the form of Rule 13.2.3, full stop. It is submitted that as per the modification, comma, such benefits were limited up to the level of E1 cadre. And in any case, comma, the petitioner became eligible only thereafter on 1/7/2010, and therefore, in any case, the rule would not be applicable to the petitioner. Full stop. As regards the submission made on behalf of the petitioner, that in spite of such modification, comma, benefits were given to certain officers who were above the E1 grade, E1 cadre, comma, Sri Senapati, the learned counsel has clarified that those were given as a special measure and on a one-time basis. Full stop. However, such benefits have not been given in any further case. Full stop. Para. The rival contentions, no. Sri Kaur, the learned senior counsel, has submitted that a rejoinder affidavit has been filed on 5/5/2022, whereby it has been clarified that despite the modification of Rule 13.2.2, comma, benefits were still given to some incumbents. Full stop. Para. The rival contentions have been duly considered and the materials placed before this court have been examined. Full stop. Now, so far as the prayer number 1 is concerned, regarding denial of promotion to the petitioner from the post of Senior Manager Civil to the post of Deputy General Manager Civil, which he claims to be entitled since 1/7/2009, comma, this court has noticed that as per records, comma, the petitioner was considered on 5 occasions on DPCs held on 2/3/2012, 30/4/2014, 25/6/2015, 7/3/2017, and 27/6/2017. Full stop. It is a settled law that promotion cannot be claimed as a matter of right, and it is only the considerations for such promotion which an eligible candidate is entitled to, which appears to have been done in the instant case. Full stop. In any case, comma, Sri Kaur, the learned senior counsel, has fairly submitted that the outcome of the said DPCs are not the subject matter of challenge. And in that view of the matter, comma, the first prayer cannot be considered. Full stop. The second prayer is regarding a grievance of delay of more than 2 years for promotion of the petitioner in the rank of Manager Civil. Full stop. This court has, however, noticed that the aforesaid grievance of the petitioner, which was espoused through the association, has been replied to wide communication dated 8/11/2004, citing certain reasons. Full stop. The said reasons, neither the said communication or the reasons are the specific matters of challenge, and therefore this court would not be inclined to hold that there has been wrongful denial of the petitioner from such consideration. Full stop. Para. As regards the third prayer concerning monetary benefit to the next higher post of Deputy General Manager by relying upon Rule 13.2.2, this court finds force in the contention made by the learned counsel for NIPCO that the said rule is not at all applicable for the petitioner. Full stop. This court has noticed that the objective behind the said rule is to give incentives to certain class of employees, officers who do not have the promotional avenues. Full stop. However, in the instant case, apart from the fact that the cadre of E6 is not covered under the said notification, as it is limited up to E1 cadre, the said notification is wholly inapplicable to the petitioner in as much as he became eligible much after the amendment done on 10/7/2009, and the petitioner had become eligible on 1/7/2010. Full stop. Para. In view of the aforesaid discussion, this court is of the considered opinion that no case for interference is made out, and accordingly, the writ petition stands dismissed.
We are obliged for giving.
Itinerary.
Eight. Somebody had mentioned this matter, Mr. Mehdi. 19 matter, why are you mentioning?
Lordship,
Why are you mentioning 19 matters?
Lordship, the petition has already expired, your Lordship.
Expired when?
The last month they have informed me, your Lordship.
No, when
If
was
they-
the expiry?
They did not inform regarding the when the it is expired, your
What is the relief you are seeking?
Lordship, the pensionary benefit, your Lord.
Pensionary benefit.
Yes, sir.
Mr. Chakraborty, what do you say?
No, my lord,
Do you have any idea, any knowledge about?
no. He has informed me that they will have to file a miscase for it.
We'll fix a date. 19 matter, we're not going to adjourn like this.
Yeah, after being.
You take the instructions if you want to pursue.
Lordship,
Since you said that it's a pension matter, we'll give you some time.
Lordship.
Sri P.K. Medhi, learned counsel for the petitioner, submits that he has been recently informed that the petitioner has passed away. And since this matter pertains to a claim for pension, he would like to have instructions regarding filing of appropriate application for substituting. Full stop. Also heard Sri S.K. Chakraborty,
Malay.
learned counsel appearing for the FCI. Full stop. Para. Considering the facts and circumstances, an adjournment is granted, directing fixing of this matter on 25th of April, 25 April. Prior to his date, the petitioner may file any application, any appropriate application.
Item 9 and 10.
My lord, I kindly take up item number 10, my lord.
Giri Kumar Viswakar.
Yes, yes, same item file. My lord, the short point involved is whether, my lord, any distinction can be made between a direct recruitment and promotion when it comes to filling up the number of advertised vacancies. Actually, what happened, my lord, 32 posts were advertised.
Of?
My lord, the accounts of, one second, my lord. From assistant audit officer to audit officer.
32, wide 83518
Yes, my lord, 3518 is the advertisement.
for 32 posts.
32 posts. But there are communications which would show, my lord, when the selection process
Post
was
of
on
audit officer,
auditor.
local funds.
Local,
Okay,
Assam local fund audit service.
okay.
Now, the advertisement was for 32. The petitioners also participated.
You were fresh candidates.
Yes, my lord, there is a system of getting exemption. That means in the next exam, my lord, we don't have to appear in those papers. Supposing there are 5 papers, and out of which, my lord, I may have failed in 1 or 2 papers.
In the
But-
first, in the earlier
in
exam.
the attempt. Next time, my lord, I don't have to appear in the papers which I have already cleared. There's an advantage.
No, no, who are eligible candidates?
No, eligible candidates are beyond number of 30.
No, no,
Our-
we are not asking that. A candidate who aspires to participate here, what is his eligibility? How does one become eligible?
No, the eligibility is not the issue.
No, we are just asking.
Are
you an in-house candidate?
We are in service.
You
So-
in-house candidate.
There is a departmental examination that we have to pass.
Okay. You are working as assistant audit officer otherwise. Okay.
And we are aspiring to become
Audit
auditor.
officer. And these are amongst all the assistant audit officer. It's not for the market.
No, it's an in-house thing.
In-house. Okay, okay.
Now, if a
How
lot,
many of you are there? Your petitioner is an or
Petitioner.
assistant audit officer?
my lord, petitioner is only one in this item number.
Okay, you are
19
assistant audit officer.
I'm an assistant officer. And we have challenged the entire selection, my lord. If lordship would kindly come to the advertisement, which is at page 30.
30.
30.
Yes, please.
Third of May 2018. This is by Assam Public Service Commission. Applications are hereby invited for the Assam Local Fund Audit Service promotion examination to be held on dates to be notified later on, filling up 32 number of posts, including backlog vacancies reserved for CST of audit officers local fund in the so-and-so scale of thing. Now, if your lordship would kindly come to page 31. Serial number 12, paragraph 12,
Just a minute, please.
page 31.
Just a minute.
এখন মনে করো।
I was going through the respondents before we proceed. One of the respondents I had appeared.
Appear.
Your lordship has taken up this matter on earlier occasion.
It was not pointed out. It will not look good. Respond number 26. In fact, her appointment case, I was the counsel.
Dimple Kolita Das. Fine.
Please before any other bench.
Your Lordship, may I say one thing? As this matter relates to 2019, can direction be issued to list on Thursday or?
You approach the registry, please before any other bench, full stop, as the parties may approach the registry for an expeditious date.
Coincidentally, in this case, my lord, there was initially an interim order that beyond 32, it should not be filled up. Then the private candidates, they filed an appeal. Writ appeal against this stay.
No. We filed a stay vacating.
Oh, sorry.
Against that.
Sorry, the stay vacation.
But her appointment was after a court case.
Okay. Oh, acha, abhi good.
I'm stay vacating.
In fact, there were 2-3 petitions, one I had appeared. Sorry.
Okay.
Mr. Pathak for another Pathak, why?
My lord. But then this Pathak is, my lord, very strangely, my lord, he is a civil caste, my lord.
Okay, doesn't matter. All are equal in front
My
of
lord,
law.
but then it's rare. In fact, I was also surprised, my lord. This title
Nothing is
not
rare.
that there, but then,
Nothing is rare. Everything is possible.
my lord. The issue, my lord, here is that is relating to selection and appointment. But then before beginning, my lord, I would like to state that there are 2 petitioners herein. The second petitioner, my lord, he has in the meantime, he has got alternative appointments, so he is not pursuing the matter. And as far as the first petitioner is also concerned, my lord, we have not been able to be in touch with her as of now as to what is her position, because there was no interim order as such. But then the limited issue was that we said that there are available vacancies against civil caste, against which we should be.
You don't have instructions.
My lord,
You don't have present instructions.
present instructions as far as the one. petition
Mr.
number one
Gupta,
is-
anything you have? Instructions, consideration part?
My lord, regarding appointment, I do not have, my lord, whether it's alternatively he has been appointed or not. But regarding,
No, if you want to pursue, you can, we can hear it now, right
My
now.
lord.
Matter of which year, 21, or if you
21.
want to have, we can have it on Thursday, if you want to have some instructions. Mr. Gupta, you can also have a talk with your
My lord.
organization. Which one? BSF?
No, this is SSB, it is voted,
SSB?
selection for all the paramilitary.
Okay, okay.
forces.
Okay.
Yeah.
What is your case?
My case is that, my lord, we had crossed the threshold cutoff mark, and therefore.
In
there-
SC
there-
category,
there-
SC category.
In the SC category.
Okay.
But then, in the reply affidavit, they have shown that, these vacancies were distributed statewide. So therefore, the statewide cutoff marks were different, and we have not crossed that particular threshold. So from that perspective, the petitioner number 1 is not qualified. But then my only case remaining then would be is that there are ex-serviceman category vacancies, which if unfulfilled are to be adjusted against normal vacancies. So as to what has happened to them.
Have you answered to that aspect?
yes, my lord.
You have answered.
in the
What do you say?
No, regarding the first issue, my lord, since the.
No, the first issue is gone. Second issue,
Second
converting vacancies of ex-servicemen.
Serviceman, my lord.
Let us decide this short issue involved.
My lord,
That is the only point
that is the
whether
only point.
they can make adjustment, and if they can make, we can, if you can make out a case, we can give you a direction. If you do not make out a case, we close
My lord,
this.
my lord, that is the only.
And first petition is also out of the thing, reckoning.
Second petitioner is out.
Second petitioner, no consideration required. Got into other job.
Yes, my lord.
There we have stated, my lord, no vacancies available, paragraph 15. Upper activity in opposition,
No vacancy in the ex-serviceman category also.
yes,
Then, Mr. Pathak,
10%.
is there anything left to be decided?
My lord, there are, as per the results declared, my lord, 361 vacancies.
Now,
are
have you
there.
stated in an affidavit
Yes,
that no vacancies are there?
yes, my lord. Paragraph 18, my lord.
Mr. Pathak, just have a look.
Paragraph. So far as their own category is concerned, my lord, since they have availed the category relaxation, they will be counted for the SC and OBC.
No, that part, Mr.
And they
Pathak
have not.
has fairly considered that the cutoff fix may be for the entire state. So if he or she doesn't make it on that, then she can at least be adjusted in the ex-serviceman category, where they say that vacancies may be there.
My lord.
If you are categorically stating that vacancies in the category of ex-serviceman is also not there,
No.
then matter gets.
There was no stay initially, my lord, so. they have
In
to
their
obtain
affidavit, in
instruction.
para 27, against our para 15, my lord, they have stated that the post reserved for ex-servicemen cannot be transferred to the law other candidates, my lord, which is contrary to the advertisement,
No, that is a point of contention that we can perhaps go in.
my lord.
But what about the vacancy part?
They have not replied anything, my lord. They have-
Where
Initially, my lord, there was no stay. Now, what is the current situation as to that recruitment
No, see,
process?
we will not do an academic exercise.
No, no.
This contention, what Mr. Pathak is saying and you are
No.
denying, that contention will go into
No.
whether it can be converted. But if you are saying that vacancies itself are not there, there is no point of going into that.
That is what.
You get the instructions
2018 advertisement. I will take the current status of the my lord, entire
day after
advertisement.
tomorrow
My lord, they have-
Advertisement process.
or tomorrow also we can have it. Day after
My
tomorrow,
lord, day after tomorrow.
day after tomorrow. But get it, huh?
No.
In para 15, we have stated that there are 361 vacancies.
I'll take
Next,
The
sir.
latest position as to what
In-
happened. my lord.
In
No,
reply to
2000
that, they have not stated.
Part three. Pathak learned counsel for the petitioners who are two in numbers, full stop. However, at the outset, it is clarified. So clarified that so far as the second petitioner is concerned, comma, she may not be interested.
He.
He may not be interested to pursue this litigation as he has been appointed in some other organization, full stop. Para. Sri H. Gupta, learned CGC, appearing for the respondents, has however contended that the issue raised may be, that adjudication of the issue, of the remaining issue may be an academic exercise only, as the vacancies of ex-serviceman category have also been filled up, full stop. He however prays for some time to get concrete instructions on this. No, no, I go to listen. Sri H. Gupta learned CGC, appearing for the respondents, has however submitted that since there was no stay order, comma, in all likelihood, comma, the vacancies in the ex-serviceman category have been filled up, and in that case, the issue raised would be an academic one. Full stop, para. He accordingly prays for and is granted 2 days time to have instructions in this regard. Full stop, para. List on Wednesday. Wednesday.
Ably okay.
Here the issue involving blockade.
And look at this appearing this case matter. After time.
Is he there?
Yes, he is in another court.
Another court. 22 meter, so we can afford to wait for some time. Be here.
Yeah, and
Made please, the lordship. Lordship, can this matter be taken up on fifth, lordship? Lordship, I'm not well, lordship.
Lordship, we have the urgency, Lordship. We are,
He's not well.
On fifth,
Lordship, we are already.
Your friend is not well.
Lordship, what happened, Lordship, with this case? Lordship,
Madam, don't make a request if you are not well.
We
If
are-
one day you are not well, we'll not adjourn matters. We know under urgency, but he said he's not well. If you're disbelieving, you can argue, but tomorrow, if you are making a request that you are not well, we are not going to adjourn.
Tomorrow, Friday, right?
No, Friday,
Thursday,
Thursday.
Thursday. Upamanyu,
Yes, Lord.
Sri D. Upamanyu.
D, Lord.
D. Upamanyu, London. Item number, give me a second. Do Miss RDV 13, item 12, no 13. 12, no 13. Learned counsel for the petitioner is present and has expressed urgency, comma, Sri D. Upamanyu. Learned standing counsel, health department submits that due to some personal difficulties, comma, another date may be fixed. Full stop para. Considering the above, comma, let this matter be listed on Thursday. Thursday come prepared,
Yes,
Thursday will dispose
I'll-
it of.
This case, the lordship, respondent authorities has filed their affidavit in opposition of in few minutes back, your lordship. So I need some time to.
You're for which department, madam?
Assam Plain Tribes Development Corporation Department.
Plain tribe.
Yes, Lord. We have filed our affidavit today.
Okay, is it on record?
No, Lord.
What was your name?
G Swami.
G Swami. MS G Swami, learned counsel of appearing for the Assam Plain Tribes Development
Corporation. Limited.
Corporation has submitted that the affidavit in opposition has been filed today by serving copy to the learned counsel for the other side. Full stop. The affidavit, let the affidavit be tagged with the records, full stop, para, on the prayer of Sri H. Barua, learned counsel for the petitioner. List after 2 weeks to enable him to seek instructions, file affidavit in reply.
In this case, my lord, though my lord, I am receiving my lord family pension, my lord, that my lord, but my lord, due to my lord some problem, my lord, it is that relief has not been totally, my lord, given to me, my lord. Retirement dues, my lord. DCRG, that come retirement
Due
receipt.
to why is it not been given?
My lord, some mistakes were there, my lord, but that
Yes.
has been already cleared.
Who is it, Mr. Medhi, you're appearing? Who is for the treasury officer? Government council or treasury officer, finance
Finance.
department,
Finance.
finance, Mr. Nayak.
Copy receipt, but their name, P. Borua receipt copy, but her name not on it. 1 lakh.
Mr. Nayak, you take instructions, we'll have it after a week. Okay, and we'll direct the, that his name may be reflected.
Yes, my lord.
Do this matter has been listed at the instance of the petitioner. Comma, it appears that the name of Standing Council Finance has not been reflected in the cause list. Full stop. Sri S.K. Medhi, learned Standing Council AG has submitted that clarification would be required from the Treasury Officer Patsala.
Yes, Patsala, my lord.
Patsala. Full stop. Para. Let a copy of the instructions be, and instructions and the connected document be furnished to Sri Nayak to enable Sri P. Nayak, who is incidentally present in the court, to enable him to obtain instructions. Full stop. Let the matter be listed for consideration on 10th. It will be okay for Mr. Nayak, 10th?
Yes, sir.
10th of April, 2024. By reflecting the name of SC Finance Department in the cause list. You give a copy.
Then I'm not bigger.
Doesn't matter. Let our colleague be there. Or we can have a date when he'll be there on 18th. Is it okay? 18th? 18th is okay?
No,
Mr. Das, 18th. 18th. Give a copy to Mr. Naik. Amar copy kore dibas. We can make 2 copies. 2 copies is no problem.
Please start there. Kindly pass over time. In understand the election code number 2.
Who is your senior?
HR code.
Time being. No, what is the matter?
Matter was SLC rejected. However, Lordship, the PHC is here, Lordship. So PHC has to get up with the instruction, Lordship, that whether his case can be again be placed before the SLC or not. Because once rejected for non-vacancy, Lordship, 5% quota was being fulfilled.
Yes, Miss.
My lord, I have been selected by the DLC in a vacant post. That is reflected in this. Everything is there.
Both the petitions. Both the petitions. There are 2 petitions.
No, my lord. Now the item Plavon Das.
Okay.
This is another case, my
Now what has happened?
My lord, my recommendation page 17 and
Now you have been recommended by DLC.
DLC
Thereafter,
on a vacant post. Thereafter, I have it is forwarded to the SLC,
SLC. Okay.
but no information are given. Accordingly, my lord, I filed writ petition before this. This writ petition disposed of directing the respondent authority for the position, what to do, everything, my lord, to furnish information, but they did not furnish any information. Then I'll file another writ petition. My lord.
Okay.
Thereafter, my lord, they furnished information that SLC rejected my case. Now I filed this writ petition to challenge this.
Rejection is on what ground?
This 5% does not fall under 5% Kedar said. So that 5% already been Lordship occupied.
The vacancy earlier, which was stated to be there by the DLC, where has that vacancy gone?
The department.
Which department?
PHC.
PH, yes, Mr. Board of
But the SLC minutes, it is clear that in this particular year, there was no vacancy for any of the applicants. And that's why Lordship, the hands are.
No, in which year DLC had recommended? The initial recommendation by DLC was of which year? Mr. Chaudhary?
Yes, this is my lord, 28 to 2019. 28 to
2019.
2019, the DLC recommended. And minus kindly see page 22. Page 22, Plavon Das, grade 4 peon, sanction letter number so and so, permanent retainer by number so and so. There is a vacant post, sanction post, this is already mentioned in the recommendation.
See, one time consideration has to be there. If there are no vacancies, that he could not even be considered, that will not amount to a consideration.
Because Lordship, that forms a very relevant part of the guidelines of compassionate appointment. Otherwise, what will happen? All of this will pile up, and in one particular year, all of these applicants will have to be.
No, see, the vacancies are restricted to 5%.
Yes, sir.
5%. If there are no vacancies at all, where is the
Yes.
consideration? If there are vacancies where some people have been considered, some found to be the best amongst the lot, then the matter ends there. But if there is no vacancy, where is the consideration?
Yes, that is what Lordship in this particular year, there was no post.
But
to
what about the
accommodate-
what about the remarks by the DLC that they have not only mentioned about the vacancy, they have given the retaining number, sanction number.
That Lordship is the prima facie exercise. After that, SLC has the final offer.
Now, did
Takes it to account.
SLC say that the DLC's finding was bad or not correct, factually incorrect. SLC has to come to that finding. SLC is the final authority, no problem. But to discard a recommendation of the DLC, there has to be some reasons cited, isn't it? And these are not reasons, these has to be, these are all factual parts. Whether vacancy is there or not. Vacancy is there, it's there.
But Lordship, here it was placed before SLC on basis of the earlier round of litigation, which is why SLC considered this in spite of not having vacancy in the end.
When was the first recommendation? 19?
1928 to 29.
And when did you approach this court earlier?
Approach, my lord, already. Page 31, my lord.
When? Which year?
Already, my lord, this is order dated 22 to 11/2022. And that
22.
20. That was, my lord, they did not furnish anything regarding whether I have been selected or not. So, my lord, I have approached before them, my lord, 2 times. They said that it will be under consideration. Having no other alternative, my lord, I approached before this court. Thereafter, my lord, after passing this order, again, they did not anything. They did not file anything, my lord. I have approached before.
Here have you filed affidavit?
Affidavit has not.
And state,
Only for this year, PLC was active, not for the other.
you have filed for DLC.
Yes, they have filed affidavit simply saying we have recommended in 2019, but since they have not filed affidavit. And
Mr. Bhattakur, file an affidavit. File an affidavit.
Will file.
And what about the second case?
Second case is different case. In the case,
In Plavon Dasu, right? It's come for the first time after notice.
yes, ma'am.
Okay.
The DLC recommended, my lord, but till date, my lord.
Notice, this case has been listed for the first time after issuance of notice on 8/9/2023. Though direction was given to list after 4 weeks. What's the para? Be there as it may, comma. The PHE department, represented by Sri I. Bhattakur, Learned Counsel, is directed to file an affidavit. Full stop. List after 4 weeks to enable such filing of affidavit. Yes, next.
Next, my lord, this is Kabiruddin, my lord. Next one is come first time.
Yes, instructions, Mr. Bhattakur.
Same submitters will file affidavit.
And what about department?
Lordship. Here, the department already has stated that there is,
Okay, you file affidavit, Mr. PHE. I go to 11/9 असेल नाही काही म्हटलं.
vacancy is not there, Lords.
Notice of motion 11/9 असेल नाही की. नाही 8/9 असेल. कुछ दो notice of motion was issued on 8/9. Why to 11/9 করে দিয়ে same 4 weeks. Okay, huh? Okay, 4 weeks.
Okay.
Please, your lordship. Lordship, this the case in brief is that the petitioner had taken part in selection process pursuant to advertisement dated 21/7/2018 in the reserve category, lordship. However, candidates of the general category who had the lowest, they had been selected and no appointment letters were given to the petitioner. It is a covered case, the lordship, where this honorable court has.
You belong to reserve category.
Yes, sir. And following this order, another order was passed.
I think we have also passed certain orders.
Yes, sir. So, lordship may take up 7588. That is the first one. First is 7.5, and then wrote 9, 10 of
Okay,
20.
madam, okay,
Got-
you do one thing.
Okay.
What is your name?
Z Islam.
Mr. Islam, you make the corrections and give it to us.
Right.
And before you give it to our court master, show it to madam.
Right.
Whatever suits, whichever order suits you.
Right.
Okay. Dispose of, huh?
Obliged.
Make the correction, recheck. There should not be any factual dispute. Okay. Ready.
May I please, Your Lord?
Yes.
My lord, on 3rd of March last year, the petitioner was recommended by DPC for promotion to junior grade 2 to junior grade 1 of Assam Finance Service. And along with him, 61 other candidates were also recommended. All have been promoted, barring the petitioner, my lord, on the ground that a regular inquiry is pending before the anti-corruption and visitors. And as per their own office memorandum, unless prosecution, the regular inquiry culminates into a criminal case, then this is not a bar, my lord.
What about Janaki Raman?
Yes,
What
my
is-
lord, those 3 conditions, my lord. These are also not here in the present.
Accepted. Only issue is that my instruction is still awaiting. So I'm praying, Lord, for some more time.
We have it on Friday, for disposal. You get any, but this will be the last part. If
Yeah,
actually there is no dispute with
Lord,
disposal.
otherwise also his case is allowed, Lord, if you would get all the benefit of. Lord, if I take up this matter after Bihu vacation, Lord, in the meantime, I will definitely have the.
Very similar, okay. I heard Sri J. Patwari, learned counsel for the petitioner who submits that in spite of being selected for promotion,
Inspector recommended by the DPC.
recommended by the DPC for promotion to the next higher grade, comma, on the issue of pendency of a regular inquiry, RE, comma, his promotion has been held up, which is not permissible under the law. Full stop, para. Sri Nayak, learned standing counsel, finance department,
Yes.
submits that though on principle, comma, the petitioner may be right, comma, he may be given some time to obtain the instructions regarding the factual aspects. Full stop, para. In the interest of justice, list on
26th, sir.
20?
Six.
26, okay? 26-4.
Deep level.
এই আমার জাজমেন্ট লাস্ট এটি কেটে আছে না এটা নহব না হ্যাঁ ওগুলো কেটে হবো এটা বোধহয় বাজি বলুন other matters will not be able to we have to pass a judgment.
If this item 12 can fix the date, Lord.
12, he'll give you a date. Okay, you are there. Okay, who's for the other side? Mr. Upadhyay?
Upadhyay was there for the other. He was
Oh,
taking
time was taken. Okay, he'll give an early
It's
date.
a very small issue.
Today, second half, we have some other
Yes, sir.
commission, so
Can it be after Bihu, Lordship?
he'll give a date. Other matters, interim order, if any, we can extend the interim order, otherwise our court master will give the dates. We'll have to pass a judgment now, fixed.
For pronouncement of judgment, the BBC produces 4,000.
This court has noticed that while making the reference on 10/9/2008, the issue was on the following terms, which had undergone a change via corrigendum of 7/3/2009 to the following term. There was no challenge whatsoever on the terms of the reference, both in its substance or the expressions used therein, and the modified issue was in fact framed by way of the corrigendum on an application made by the union. Therefore, the submission made on behalf of the petitioner that the issue was not clear is both factual and legally untenable. This court has also noticed that the modified issue presupposes that the lockdown was declared after the period of strike. When the provisions of the act pertaining to strike are clearly violated, the strike has to be declared illegal, in which case section 24(3) would come into operation. It is a settled law that a labor code is a code of facts wherein A conclusion is arrived at after consideration of the rival contentions and the evidence on record, and unless such conclusion is prima facie demonstrated to be perverse or wholly illegal, wholly unreasonable, this court in exercise of powers under 226 of the Constitution of India would not interfere with such findings. In this connection, it would be gainful if the observation of the Honorable Supreme Court in Calcutta Port Trust is referred to. We have quoted. In view of the aforesaid discussion, court is of the unhesitant view that the impugned or award dated passed by the so-and-so does not require any interference, and accordingly writ petition stands dismissed.